Welcome to Rainbow Network Media. Please kindly subscribe to this channel for interesting news. Thank you all for listening. The rule of law and the constitutionalism have finally been nailed to the coffin in Nigeria by President Muhammadu Buhari. Throughout the history of democracy, rule of law and constitutionalism in the country, be they parliamentary or presidential, Nigeria had never experienced the kind of insult, mockery, and bastardization it's presently experiencing under Muhammadu Buhari's regime. Human rights records of the present administration are also negatively alarming, shocking. All the third generation of human rights, civil, political, economic, social, cultural, environmental, and development community rights are observed in gross breach by the Buhari administration. Nigerian judiciary under his administration is no longer the basis of democracy and last hope of the common man. It is now a leprosy arm of government, being mocked and cajoled from left, right, and center. A civilian government that makes mockery of and disobeys the rule of law and the constitutionalism is worse than a madman running amok with a sharp dagger in a crowded marketplace. Citizen Nnamdi Kanu is today made a prisoner of conscience by President Muhammadu Buhari and his DSS. The President and his DSS had in the past 60 days flaunted and gravely disobeyed 4 express and consequential orders of the Wuse Zone 2 Magistrate Court and the Federal High Court, Abuja Division, bordering on citizen Nnamdi Kanu's constitutional right to personal liberty, association, assembly, dignity of human persons, life and expression. It is freshly recalled that on 19th October 2015, His Worship Honorable Shahibu Usman of the Wuse Zone 2 Magistrate Court in Abuja granted conditional bail to Nnamdi Kanu, and on 22nd October 2015, all the bail conditions were fulfilled, but the DSS refused to release him on bail, claiming it was acting based on personal directive of President Muhammadu Buhari. The magistrate court order for his bail was followed by 2 other consequential orders, which were also flagrantly disobeyed by the same DSS. On the 18th November 2018, the DSS told the Wuse Zone 2 Magistrate Court that it had on 10th November 2015 secured an expert order from the Federal High Court, Abuja Division to detain Nnamdi Kanu for 90 days for the purpose of investigating him for terrorism and terrorism financing, using the flawed defense of unconstitutional Section 27, subsection 1 of the Terror Act of 2011 as amended. On 17th December 2015, the same Federal High Court, presided over by Honorable Justice Adeniyi Ademola, struck out and dismissed the DSS fraudulently and unconstitutionally obtained 90 days detention order and ordered for immediate and unconstitutional release of Nnamdi Kanu. The DSS again flaunted the order and introduced delay tactics attached with stringent conditions to frustrate the signing of the final discharge papers at the Federal High Court that would have allowed Nnamdi Kanu to go home same day. We were shocked to observe that 24 hours after the DSS brazen resort to delay tactics and stringent conditions, contrary to the order of the Federal High Court, it came up again with further delay tactics, claiming that its DG must be present and personally sign Kanu's administrative release order. All these delay tactics were going on. The presidency reportedly called and definitely directed that Kanu must sign an undertaking renouncing his pro-Biafran agitation as a condition for its compliance with the court order, failure on which he should remain detained in the DSS custody and be slammed with fresh accusation of treasonable felony. It was on account of the insistence of citizen Kanu's lawyer that the order of the Federal High Court must be obeyed and enforced to the letter that the DSS refused to release Kanu, claiming that he was being held on suspicion of commission of treasonable felony. Kanu's lawyer and family members and friends spent over 14 hours from 10 a.m. midnight waiting for the DSS to release him to them as ordered by the Federal High Court, all to no avail. Also, the avoidance of doubt, the offense of treasonable felony is defined by Section 41 of the Criminal Code as follows: any person who form an intention to affect any of the following purpose, that is to say, to remove during his term of office, otherwise than by constitutional means, the President as head of state of the Federation and Commander-in-Chief of the Armed Forces thereof, or to likewise remove during his term of office the governor of the state, or to levy war against Nigeria in order to put any of the force or compel the president to change his measure. Provided below is the detention time limit under Part 30 of the Administration of the Criminal Justice Act of 2015, relating to stipulated period upon which a citizen accused of committed any offense in Nigeria can be held in partial detention through court demand pursuant to application for an issuance of other experts. So guys, it's been said and it's been noted that Muhammad Buhari is behind the DSS refusal to release Nnamdi Kanu despite the court order. So guys, let's know your own thoughts concerning this news. Please kindly subscribe to this channel and don't forget to always follow for more updates. Thank you all for listening.